Can an employee sue a company for using the employee's code in the company's software? If the employee put her code into the company's software, and then let's say the employee is fired, can she sue the company? For example, could she sue for compensation for the continued use of the software? She definitely could sue. Whether she could win is another analysis. Here's why. I believe an employee could make a reasonable argument, which goes like this. While I was working in the company, I was being compensated through wages, so I didn't mind my software being used without any additional compensation to me. But in light of the fact the company has fired me, and the company wants to continue to use my software code, which I own the copyright to, I'm entitled to reasonable license fees. The company does not have a right to use my software code for 100 years when I am no longer receiving any benefit from that. So that is a very reasonable argument, which could get you into court, and so you have every right to sue over that. But then the question is, would you win? Well, the company is going to argue that maybe they didn't even know about it and you should have disclosed it. But now they're relying on it. It probably doesn't have much worth anyway, is what they would argue. They'll argue you were being paid to write the code for the company. The fact that you use your own code was actually a violation of your duties. You should have written code, or at least you should have used code that the company could use indefinitely. It was improper of you to use code that was subject to copyright and would incur license fees to the company for the future. The company would argue that they already paid you a reasonable wage. They never agreed to license fees. And to the extent that you replaced your own services with code that you had previously written was on you. The company should not now be subject to ongoing license fees for code they never even knew about and code they never agreed to. You should have used code that was not subject to license fees. Who wins in this case? I think it's a tough one. Honestly, it could go both ways. I think there's a higher likelihood of the company winning with the facts I've presented here, but it very much is going to depend on the circumstances. I also think the value of the code is going to matter. For example, if it's a small amount of code that would have taken 5 hours to write, I don't think the employee is going to get any compensation for that. But if the employee spent 20 years writing this code, or that's probably unrealistic, but let's say 5 years writing the code before joining the company, and it's a significant portion of the company's code, I think a judge will look at that and go, you know what, the employee deserves some compensation. Yeah, the employee probably did wrong. Shouldn't have used that code without telling the company. I think the judge will say there's no way that the employee could have just written this on company time and wages would have adequately compensated the employee. The employee used years worth of code, and equity dictates, or justice dictates, that a person who does this work should be compensated for it. So in summary, it could go either way. It will very much depend on the circumstances, but if I had to guess, I would say the company is likely to win unless there are extraordinary circumstances. If you found this video helpful and you would like more educational videos like this, feel free to subscribe to this channel. If you have other questions, put them in the comments below. I'm Aaron Hall, an attorney for business owners and entrepreneurial companies. You can learn more about me at aaronhall.com, and if you'd like to sign up for our free resources, go to aaronhall.com/free. It was great to be with you here today.